Good evening, friends. Rishikesh Vyas, along with Udant Saluters, welcomes you all for today's session on Insolvency Code. First of all, I would like to welcome Advocate Chetan Kapadia and offer a thanks on behalf of Udant Saluters. I also take this opportunity in welcoming Advocate Akash Menon. To sum up the topic of the Insolvency Code in India, perhaps these four words, Kabhi Kushi, Kabhi Gum, are perhaps to perfectly to sum up the IBC track record in India. As of 31st December 2019, around 190 companies that had defaulted on loans have yielded resolution plans with different degrees of realization. Claims were 3.52 trillion in total had been filed by financial creditors, which are primarily banks. Of this, around 1.52 trillion, that is around 43% of the claims under consideration, has been recovered. This is much better than the rate of recovery before IBC was put to place. Take the case of 2015-16 financial years. Of the total bad loans up for recovery were 2.21 trillion. Only rupees 22,768 crore or 10.3 of the loans were recovered. So we can see there is a difference of around 30% in the rate of recovery pre-IBC and the post-IBC. Now I will request Advocate Akash Menon to formally introduce the speaker for the day.
Good evening, friends. It's a pleasure to be amongst all of you and in the presence of Mr. Chetan Kapadia, a stalwart in the Bombay High Court, if I may say so. As someone who's grown in the bar, it's always been a pleasure learning from Mr. Kapadia, hearing him argue. And what I found personally as a junior to him, what I found personally very endearing about him was the fact that whether you meet him in court or you meet him in the middle of the road, he always gives you a lovely smile and is extremely approachable. From a professional front, Mr. Kapadia has a thriving practice on both the original and appellate side of the Bombay High Court, practicing in civil, constitutional, company and arbitration matters. He appears in the Supreme Court, various high courts and tribunals, including the NCLT. He is represented the Union of India as the senior panel counsel, was a member of the Standing Committee of the Bombay Bar Association and the Committee for Organizing Educational Workshops for Young Aspiring and Budding Lawyers. Mr. Kapadia is also a passionate public speaker on diverse legal subjects. Without further ado, I would invite Mr. Kapadia to take over the session and lecture us on the Insolvency and Bankruptcy Code.
Sorry, Chetan Bhai, sorry. Just I would like to add one thing. Chetan Bhai was very kind in circulating a brief note, which is something like a ready reckoner for all the participants for today's session. And we have already emailed that to all the participants who are registered till around 1 p.m. today afternoon. Whoever has been registered thereafter will also be circulating the same to everyone. Yeah, Chetan Bhai, now all yours.
Thank you, Rishikesh. Thank you, Akash. Firstly, I must congratulate both of you all and your organization for endeavoring to learn and improve knowledge not only of members of the legal fraternity but other people associated during this lockdown. It is a step in right earnest in the correct direction, because while we all sit at home and do our little tidbits of domestic work at home trying to help everybody, we must at the same time find ways and means to keep ourselves occupied and also learn. Well, so congratulations on this continuous learning and knowledge improving endeavor by both of you all. I wish both of you all the very best. And now, friends, coming to the topic of the day, the concepts and practice of the Insolvency and Bankruptcy Code. So before we go to the concepts covered under the IBC, let's just have a brief precursor, a look at the situation which existed before the IBC came about in 2016. We all know that in the world, in the realm of litigation, there is a particular kind of litigation which is at the top of the pyramid. That is the litigation in relation to recovery of money. It forms a very large part of civil litigation, and as lawyers or as anybody or everybody associated in any kind of practice, whether you are a chartered accountant, whether you are cost accountant, or you are a businessman or any kind of professional, you always come up with this question about what is the most efficient way to recover a sum of money which is payable by somebody, but that person is in default. And usually this question is also posed in the reverse, because people who owe money don't have ability to pay that money, and therefore approach professionals because there are disputes, there are differences, there are issues, there is lack of intent or whatever else. And therefore the traditional methods which used to be available to a creditor or a debtor when there was a dispute in regard to payment of money between parties was you could file a civil suit in a court of law, which is into two categories: a regular suit, which all of us know would take 5 years, 7 years, 10 years, 12 years, 15 years to get decided, or a summary suit, which was a shorter version and available to a few kinds of transactions which were, for example, a promissory note transaction, a bill of exchange transaction, a deed of guarantee transaction, a contract in writing, in short. A contract in writing, if existed between parties, needed to be enforced for a crystallized sum of money to be recovered, could be a basis for filing a summary suit, which took lesser than the longer period that a regular civil suit took. But well, even that took 2-3 years usually, and there was an appeal available to the Supreme Court in case the defendant lost very badly, that is, there was an order of decree, or if there was an order of deposit, then an appeal to the division bench and then to the Supreme Court. So, well, these are the two kinds of proceedings. In addition to that, lawyers also used a third method, because companies are very popular in the course of doing business, and if the debtor is a company, then one could institute a winding up petition after issuing notice, which is typically a 433 notice under the 1956 Act, calling upon the company to pay and invoking the deeming fiction that if the company doesn't repay within 21 days, then there is inability to pay debts and therefore the company is liable to be wound up. Well, even that proceeding faced a similar fate. That is, it took 2-3 years to reach fruition. There was an order of admission. If the company was a little healthy, it came about settling the matter, and if it was sinking, then, well, only God could possibly enable payment. So, civil suits, winding up petitions were two popular remedies, both available either before the civil court or the company court for the recovery of money. Not finding these methods efficient for a class of creditors in our country, that is banks and financial institutions, who have a huge stake in the lenders market, so to say, the government came up with the RDB Act, that is the Recovery of Debts Due to Banks and Financial Institutions Act, setting up a separate tribunal, namely the Debt Recovery Tribunal, so as to take up cases where the lenders were banks and institutions. And that was introduced in 1993, became effective in Bombay in 1999, that is the state of Maharashtra. And a few years passed, and even that was not found to be good enough. Reason being, our economy, because of the liberalization post 1992, was growing at a very fast pace. And it was very important for our justice dispensation system to keep pace, because with the growth of the economy, it was equally important that money which was payable by party A to party B did not get stuck in litigation. And it was found that the DRT mechanism was probably not enough. Therefore, the government took one more step to aid banks and institutions from recovering their money. It came up with the Securitization Act, which enabled banks and institutions not needing to enforce their mortgage by obtaining a decree of redemption and foreclosure, but straight away proceeding with issuance of a notice under the Securitization Act, and thereafter taking possession and selling it without need to file a proceeding before the Debt Recovery Tribunal and obtaining a decree of redemption and a foreclosure and then selling it through the recovery officer. So in short, these are 5 kinds of different remedies available to entities or a class of entities, namely banks and institutions, for recovering their money. Now, all of this with the growing economy and the desire of the governments from time to time uh, wanting to improve what possibly could be done by creditors when they were facing defaults from their debtors. So these were the methods, and they were found to be grossly inadequate. And with every passing day, as we have read over the 1990s and the first decade of 2000 and thereafter 2010 onwards, it was found that lakhs of crores of rupees within the system were stuck in litigation. And companies which had not paid were merrily going about creating further liabilities, and the promoters of these companies were going scot-free, and they were still in control of the company. Now, while this was the method for recovering of money, we must also look at another legislative framework available to promoters for the remedies which companies could invoke when they were facing financial stress. Namely, what could a company do if it was facing financial stress and it wanted to resolve its affairs? There were 2 primary statutes, one at a central government level and one at a state government level, available to companies which were involved in manufacturing activities, namely industrial undertakings, who were considered the backbone of the Indian economy, so to say. One was the Sikh Industrial Companies Act, which enabled a company whose net worth had eroded to approach the Sikh Industrial Companies Act forum, namely BIFR, and it could file a reference before the BIFR and eventually churn out a resolution plan. One of the typical features of SICA was that while the reference was pending before SICA, the company, its guarantors and its contracts all were frozen, and there was no enforcement possible at the hands of any entity who had a right against the company or the guarantors, etc. So that was the protection accorded to all stakeholders in the company against creditors or parties who claimed rights against the company. It was found by experience that very few companies actually revived after filing references in SICA, and it was also noticed that promoters were most often taking advantage of the blanket protection that SICA accorded to them by dragging proceedings for years together, in some cases more than 10 years, and in the process the creditors lost the value of what they had to recover from the company and eventually got precious little out of the company. A similar state legislation, which was also found to be misused by creditors, by the debtors and the companies, was the Relief Undertaking Statute, which in Maharashtra was called earlier the Bombay Relief Undertaking Act, and is now known as the MRU, that is the Maharashtra Relief Undertaking, giving similar protection, albeit only for 1 year, because the notification was issued from time to time under the Act for a period of 1 year. So these were the fragmented statutes operating in the field, in addition to the regular insolvency provisions applicable to presidency towns and rural areas and urban areas. Now, with these fragmented legislations, on the one side for recovery of money, on the other side for bankruptcy and insolvency, and on the third side for rehabilitation of a company in financial stress, it was noticed that the average time taken in India was very, very long for recovery of money or for liquidating a company or for revival of a company. And there was no effective mechanism available on the table. On the one hand, while the Indian economy and the participation of foreign companies, foreign investors in the economy was increasing on a day-to-day basis. Therefore, the government thought it fit that there was a time to get rid of this fragmented and unsatisfactory statutory framework. So it came up with a consolidated single statute, a code, namely the Insolvency and Bankruptcy Code in 2016. Now, why do I say it's a fragmented a situation pre-IBC and a consolidated one post-IBC? Well, the IBC takes within its ambit and scope a large number of functions and activities which were earlier part of or scope of several statutes before the IBC came about. IBC deals with, so to say, the winding up or the closure of companies, of limited liability partnerships, of individuals, of partnership firms. It also deals with the resolution of all these four entities. It deals with all claims of all creditors and all stakeholders in regard to all these entities. And in addition to that, it sets up an entire framework of all intermediaries and professionals associated in this entire exercise, initially of getting a revival plan in place for the purposes of bringing about a change in management of a company or a partnership firm or an LLP, and thereafter a liquidation either as a going concern or on a piece-by-piece basis of the assets of entities who are covered under the IBC. Therefore, the IBC is a consolidating statute, a code which covers the entire regime of reorganization, insolvency resolution, and upon failure of insolvency resolution, liquidation in regard to all these entities. Now, the objective of the IBC is therefore that the whole regime should function in a time-bound manner for maximizing the value of the assets of such entities and to ensure that the maximum value is received by the stakeholders in the defaulting entity, namely the creditors. Now, this was necessary because the Indian economy, as I mentioned earlier, was facing a low ease of doing business, difficulties in recovering money, whether it be a private creditor or banks and financial institutions who had NPAs to the tune of lakhs of crores of rupees. There was an uncertainty because of the delays in the process of recovery of money, and the recoveries were of very low value, and there was a huge loss of value. And lastly, there was an absolutely inefficient manner in which a platform was available for the process of stress resolution of companies facing financial strain, leading to an overall strain on the economy as a whole. Therefore, with that background, the IBC was brought about, and the IBC, containing 255 sections and divided additionally into 12 schedules and 5 parts for the 255 sections, is a statute which gives very strong rights to the creditors. Legal rights of the creditors are stronger than the legal rights available to the promoter, on the basis that promoters of a company who were in season, who were running the day-to-day management, who were taking decisions in regard to every aspect of the company, had committed default, and therefore they no longer could claim any rights in regard to the operations of the company, the management of the company. And the stakeholders, namely the creditors, needed to be given strong legal rights so as to ensure that the recovery of the dues of the creditors is to the maximum possible extent, keeping in mind that maximization of value in the assets of the company would result in the benefit of the creditors who had otherwise faced default in regard to their payments. With this, there is one more principle which ought to be borne in mind, that in the operational experience of the IBC, it is found that the code aims at revival of the corporate debtor in the first place, with liquidation being kept as a last resort situation. Therefore, the best efforts are initially put not on closing the company, but ensuring that the company is maintained with its present activities, and a suitor, an interested party who wants to take over the assets and the business of the company is found. And the last option is that the company is closed. And while all these efforts are taken, what is very striking, what is noteworthy is that the inefficient management the management which was responsible for the company having committed defaults is kept out of the picture, except involved to the minimalistic extent of taking data, details, and kept in the loop so far as the resolution plan, the resolution process is concerned. But otherwise, the management is vested in what is known as an officer under the IBC, that is a resolution professional, initially called the interim resolution professional and eventually the resolution professional, who manages the company as a going concern during what is known as the corporate insolvency resolution process. So therefore, post December 2016, this act came about, and after that, it has run its course during the last 3.5, 4 years and has been very successful. Now, the next question which comes to our mind as we embark upon a look into the provisions of the IBC is, whom does it apply to? And while the statute is applicable on the whole to corporate persons, that is companies incorporated under the Companies Act, earlier 1956, now 2013, LLPs who are governed by the Limited Liability Partnership Act, it also covers firms and individuals. But presently, the provisions in regard to firms and individuals are not yet notified as operational by the Government of India. And in addition to that, it also applies to personal guarantors to corporate debtors and other individuals. Now, therefore, presently, our discussion today will be limited to the operational parts of the IBC, that is the provisions which cover corporate persons, namely companies and LLPs, as the provisions in regard to partnerships and individuals are not yet applicable. I must just depart from that saying that the jurisdiction in regard to the bankruptcy of partnerships and individuals is vested with the Debt Recovery Tribunal. So as and when the whole code will become applicable, namely the provisions relating to partnerships and individuals also, we shall have the Debt Recovery Tribunal deciding disputes in regard to that part of the code. Presently, therefore, the NCLT, that is the National Company Law Tribunal, is the tribunal vested with jurisdiction to decide the operational parts of the IBC, namely the resolution process and thereafter the liquidation process and the consideration of applications filed by operational creditors or financial creditors or the corporate entity itself, namely the corporate person who desires that it wants to itself apply for its commencement of corporate insolvency resolution. So all these jurisdictional aspects are presently vested exclusively in the NCLT, with the IBC providing for overriding effect over all other laws, which we shall discuss a little later in greater detail. Now, the salient feature in regard to the IBC is that over the last 3.5 years, the IBC being as successful and as all-pervasive in its impact over the corporate economy of the country, the government has been extremely proactive and has been constantly amending the insolvency and bankruptcy code with the experience gained in the course of its implementation and the issues which have arisen in the course of its being rolled out. In a very short time, there are several Supreme Court judgments which explain the various tricky aspects or the contentious aspects or issues which have arisen in the course of litigation between parties under the IBC. And very, very importantly, I can say that the IBC has come a very, very long way in the course of its implementation, because our country as a sovereign earns a place among the world's top 10 improvers for the third consecutive year, which has been issued by the World Bank. And one of the very big reasons why our country has been able to achieve this is because the IBC has, to a very great extent, assisted the recovery of money or the closure or the revival of companies who have been in default in our country. Now, with that little background, if we just focus on a few concepts under the IBC, namely the concepts relating to how the decision-making process is undertaken and what are the key aspects which one must bear in mind while practicing the cases under the Insolvency and Bankruptcy Code. We all know that when it comes to recovery of money, there must exist a claim. So, claim is a serious concept under the IBC, and clarity in that regard must be there in our minds. Well, in ordinary parlance, as we understand, claim would mean a right to any payment, whether such a right to payment has been converted into a judgment, or whether it is fixed, or whether it is fluctuating, whether it is disputed, etc., etc. So, therefore, in order to be an applicant in regard to a monetary claim, we must have a sum of money which is not only due but also payable by the corporate debtor to the applicant. So that is a starting point, a good starting point, which we must clear in our own minds to be sure that we can file a case in the NCLT invoking the provisions of the IBC. So a due and payable claim is the starting point of any application under the IBC. The second concept is corporate person, and the reason why I have included corporate person as a concept in this discussion with you all is because a corporate person is not restricted to simply a company under the provisions of the Companies Act 1956, now 2013. It also includes a limited liability partnership. So the scope of the IBC for the purposes of default, for the purposes of claim, for the purposes of revival, for the purposes of resolution is not only applicable to a company but also applicable to a limited liability partnership. So therefore, corporate person in that sense defines the ambit and the scope of the applicability of the Insolvency and Bankruptcy Code. So this corporate person must be a corporate debtor in order to commence an application. With that, we go to the next concept, which is the concept of debt. Now, whenever a claim is a sum of money of various kinds, which is a liability or an obligation, and is due and payable from a person, and which could be any kind of debt. It could be a debt for a sum of money lent in advance, a sum of money which is payable under an indemnity, a sum of money which is payable under a guarantee, a sum of money payable under a letter of credit which has thereafter been encashed, or ordinarily we understand all these to be financial claims, whereas there are claims for rendering services, there are claims for salaries. Those fall in a separate devised category under the Insolvency and Bankruptcy Code, namely operational debts. So therefore, the larger definition of debt would be a monetary obligation or monetary liability which one has towards another and which is due and payable and could be categorized further down into a financial debt or an or an operational debt. Now we have understood claim and we've understood debt, but what also needs to be understood by us is that that claim also must be a claim which is due and payable, which is a debt due and payable, and in regard to which there is a default which has been committed. So therefore, the third, so to say, step of this pillar is that there, in addition to the fact that there is a claim, that claim is a debt and that debt has been defaulted, namely, there is a non-payment of a sum of money which has become due and has become payable and that is not being paid by a corporate debtor, as a result of which there has been a default in the obligation to pay by the corporate debtor. Now the next concept is an insolvency professional, who is a person enrolled under section 206 of the IBC with and registered with the board and is capable of rendering services under the IBC as an insolvency professional. He is a very important office under the IBC because, as you will see in our discussion a little later, large number of powers, varied functions, and serious responsibility is cast on the insolvency professional in the implementation of the IBC. To put it mythologically, he is the charioteer in the CIRP process, that is the corporate insolvency resolution process, insofar as the corporate debtor is concerned, and therefore a very, very important and central figure in the implementation of the IBC. That takes us to two twin concepts, that is a financial creditor and a financial debt. Now, financial debt is quite a wide definition, and it includes a sum of money which has been disbursed and payable along with interest, or in the absence of interest, it includes a consideration for time value of money. Now, we all understand time value of money, that is a sum of money, and then in addition to that, correlated with the time that it lies with the other person, an addition in its value on the original amount given. So it would include money borrowed on interest, amount raised under various credit facilities. We have purchase notes, we have lease and hire purchase agreements, we have discounting, we have any other transaction for forward sales, we have derivative transactions, we have indemnity obligations, and we have deeds of guarantee, all of which cover situations where there is a sum of money involved between two parties and there is a time value of money equally associated in that transaction between parties, which results in a claim arising and eventually a default which could give rise to a debt in regard to which a default has been committed. So, as you have seen, financial debt covers a wide array of financial obligations which could be covered between parties, and that wide array of obligations is covered under the definition of financial debt, and the person who has a financial debt in his favor against a corporate debtor is termed as a financial creditor under the IBC. Now, with that, we come to the next kind of creditor, namely an operational creditor. Now, operational creditor is a creditor who is entitled to recover a sum of money from the corporate debtor because he has either supplied goods of some kind or the other to the corporate debtor, and as a result of that is entitled to a sum of money, or has rendered services to the corporate debtor and is entitled to the fees or the charges or the compensation which that service provider has given from the corporate debtor for the services rendered. Now, therefore, operational creditor essentially covers two kinds of creditors, namely somebody who has supplied goods or somebody who has supplied services to the corporate debtor. Now, therefore, broadly speaking, as we have seen, the division is between financial creditors and operational creditors who can, upon there being a claim in their favor, a debt which is due and payable, and in regard to which a default has been committed, entitled to invoke the provisions of the Insolvency and Bankruptcy Code. The manner in which these applications are filed and the prerequisites we shall discuss a little later. But before that, I want to draw your attention to four salient features of the IBC, which are extremely important and necessary. As we have seen, one, IBC is a legislation which has been enacted for corporate revival and ensuring that the capital infusion in the economy is done by ensuring that money doesn't remain stuck up during long periods of litigation between creditors and debtors and is available to the economy. Therefore, the threshold limit under the IBC has been fixed at 1 crore rupees now, but originally was 1 lakh rupees. 1 crore is a recent amendment during the COVID-19 pandemic which we are facing. And therefore, an insolvency resolution process can be triggered either by a financial creditor who had a claim a debt, a default of more than 1 lakh rupees, now 1 crore rupees, or an operational creditor who had such a claim. The third option was that the company itself thought that its affairs are not being run in the most optimum manner, and therefore it is necessary that it applies to the NCLT for the purposes of a resolution plan, and therefore it is open for the company itself by filing necessary application to the NCLT to start a corporate insolvency resolution process in its regard. Now, therefore, the NCLT has jurisdiction to determine applications and cases filed by financial creditors, filed by operational creditors, or by the company itself. Now, essentially what the NCLT does is a limited adjudicatory process, namely, it takes up the application. Just give me half a second. It takes up the application, and upon examining it and hearing parties, of course, either accepts it and or rejects it. And once the application is accepted, what happens is the CIRP process commences. Now, the CIRP process has 3 major consequences, which we shall discuss a little in detail a little later. But one of the important salient features of the IBC is that there is a time-bound process which it prescribes, and if that time-bound process is implemented in its fullest zeal, then we will find that corporate persons will really not want themselves to be dragged before the NCLT at all. So one of the important salient features is that there is no endless pendency in regard to a debt and a default. Within the specified maximum period of 180 days, which is extendable to the highest extent of 330 days, the entire process in regard to a corporate person is required mandatorily to be completely over, failing which the company must go in liquidation. Compared to the past timelines which used to be followed by or any kind of litigation processes, that is obtaining a decree and thereafter executing a decree, or obtaining an admission order of winding up, a final order of winding up, and thereafter the official liquidator taking steps to sell the property. In all these situations, 180 days or 330 days was almost nothing. And now in the last 3.5 years, we have seen that in most cases, several attempts are successfully made by the resolution professional in trying to revive the company with the assistance of the COC, and the COC, that is the Committee of Creditors, steering the process of insolvency resolution. And eventually, if that doesn't happen, the NCLT makes a quick decision to order liquidation of the company, either as a going concern or on an asset-to-asset basis. So therefore, a time limit has made a world of a difference in the implementation of the NCLT, of the implementation of the IBC. Now, the next salient feature is that while in most judicial processes, there is a huge court participation, there is a huge involvement of judicial time and participation, and therefore parties are able to take advantage of it and delay the process. So far as the IBC is concerned, there is very little participation or interference from the tribunal or the judicial process. Once there is an order of admission made, the next stage at which the tribunal is involved is straight away for accepting or rejecting a resolution plan, if there is a resolution plan, or in the alternative, if there is no resolution plan, then ordering liquidation of the company in question. The entire process between the admission and the liquidation or the acceptance of resolution plan, the entire process is steered by the resolution professional, and all decisions in regard to the company are made by a body known as the Committee of Creditors, that is the COC, which essentially has participants from the various creditors of the corporate debtor who have to recover sums of money from the company in question. Now, the next essential feature of the IBC, which needs to be borne in mind, is that in addition to interference and a time limit, you will notice that the IBC completely hands over charge of the company from the inefficient and probably dishonest promoter of the company into the hands of an independent professional who is the resolution professional. Therefore, the IBC is tilted in favor of the creditor. Very strong legal rights are given to the creditors, and the promoters of the company are completely divested of any participation, any control, and any decision making in the affairs in the management of the company on and from the day an order of admission is made by the NCLT in regard to an application filed against the corporate debtor. The last aspect which I want to point out is that so effective is the IBC, so useful the IBC has proved in the Indian resolution process, that even during these times of lockdown, the government has been very active so far as the IBC is concerned. In addition to the numerous amendments made during the last 3.5 years in the working of the IBC, last 4 years, even during these COVID times, the government, by showing its proactiveness, increased the limit for IBC claims from 1 lakh to 1 crore rupees. The Insolvency Board has granted extension of the time period lost during the lockdown period. And in addition to that, there has also been an announcement in the recent past, about 2 to 3 weeks back, that the government is seriously considering suspension of the provisions of Section 9, Section 7 and Section 10 proceedings for a period of 6 months, although there is no formal amendment announced, but a decision has been taken at a cabinet level that for a period of 6 months, the provisions of the IBC should not be made applicable in view of the extraordinary financial stress faced by entities operating in our country. So the government has been active, and the reason why the government has been so active so far as the provisions of IBC is concerned is not far to see. The reasons are obvious. The reasons are the effectiveness of the IBC in the general economic scenario which the country operates in. And because of its effectiveness and because of its useful features, the government has thought it and fit it necessary to introduce these amendments, increasing the threshold limit and providing for a suspension period and providing for an extension period of the time limits under the IBC. Now that takes us to the operational portion of the Insolvency and Bankruptcy Code, that is a claim, an application to be filed by a financial creditor, a corporate debtor, or the operational creditor, as the case may be. Now, therefore, let's first take up an application under Section 7. This application under Section 7 is to be an application by a financial creditor, contradistinguished with an application under Section 9 by the operational creditor. Now, all of us are familiar that a financial creditor is usually an entity who has a transaction which is relatively clearer than the transaction of an operational creditor. There are various reasons why there are two classes in terms of division. We have a very, very large creditor outstanding of banks and financial institutions. We also have a huge category of NBFCs and finance companies. And we have an entire monetary and financial sector under which large sums of money are exchanged between parties under financial transactions. Now, all these transactions are usually reduced in writing, are captured in documents between parties, and are in that sense a crystallized sum of money, easy to discern in a judicial adjudicatory process. Now, therefore, the proof in regard to a claim, the proof in regard to a debt, and the proof in regard to a default is required to be annexed to an application, and an application under section 7 with the necessary proofs can be filed. Once that application is filed with the necessary proofs in regard to claim, in regard to debt, and in regard to default of that debt, namely that a sum of money was due and payable, that obligation has become crystallized, and despite the crystallization of that obligation has not been met with by the corporate person, that is sufficient along with the necessary documentary proof for a successful application to be filed by any creditor who claims to be a financial creditor. Here I must take a pause for a second and add that by legislative process now and earlier by interpretive process, it was found that an allottee in regard to a unit in an immovable property where the developer has failed in compliance of his default to that allottee is also categorized within the financial creditor expression, and therefore can invoke the provisions of section 7 and file an application before the NCLT. Therefore, in addition to all the financial transactions which we discussed earlier, the allottee in regard to a failed development project also is capable of seeking refund of the sum paid by him by invoking the provisions of section 7 and filing an application. Of course, now by a judicial process, that is by amending the section, what has been done is there is a minimum number which has been prescribed, because in very large projects, it should not be a situation where the entire project is destroyed by an application being filed by a single allottee, and therefore a minimum number or percentage of allottees from the project must get together before being able to maintain an application as a financial creditor. Now that takes us to one of the very important decisions rendered by the Supreme Court in the case of Innovative Industries versus ICICI Bank, which is reported in 2018 1 SCC 407, in which the Supreme Court makes it abundantly clear that all that the NCLT has to do is it has to be satisfied that a default has occurred, and if it is satisfied that a default has occurred, namely there is a debt, and in that debt there has been a failure to pay upon the debt becoming due and payable, resulting in a default. And if that default has been committed, then NCLT has no choice. It has no discretion. Other factors cannot be taken into account, namely hardship, namely prejudice, namely interest of other parties. None of those factors could weigh in the mind of the NCLT. NCLT is obligated thereafter to accept that application and admit it, and the consequences of such admission should follow. Therefore, admission is not dependent on existence of disputes with financial creditors, hardship, or any other similar criteria. Once it is established by the financial creditor that there is a debt and there is a default, it should result in an order of admission. That is the judgment of Innovative Industries versus ICICI decided by the Supreme Court. In addition to that, there is one more judgment which I want to draw your attention to, which is the judgment which paved the way of the amendment of the IBC so as to bring about allottees within the realm of financial creditors. That is the treatment of real estate allottees as financial creditors being constitutionally valid, and therefore the residuary provision subsumed within itself allottees of flats and apartments is what was held by the Supreme Court. And therefore, earlier, while only one allottee could have dragged a developer to CIRP, now 100 allottees or 10% allottees, whichever is less, are required to make an application to the NCLT under Section 7 for commencement of a CIRP process against a corporate debtor. One more aspect which you all need to bear in mind is that it's not as if any claim which is existing by a party against the corporate person can be filed. The claim must be within a period of limitation. And that is explained by the Supreme Court in the case of DK Educational Services versus Parag Gupta. In short, meaning that the right to sue must have accrued within a period of 3 years before the filing of the application. Meaning thereby that you couldn't have had a claim which became due and payable in 2010, in regard to which you filed a civil suit in 2012, which is pending before some court. And based on that claim, you file an application in the NCLT saying that, well, the NCLT has just come about in November, December 2016, and therefore in 2018, that is within a period of 3 years, I have filed a claim. In short, the Supreme Court was clear that the IBC could not resurrect time-barred claims by making them within time, and therefore a claim needed to be necessarily within time to successfully maintain an application under the IBC. Therefore, all these and more are important judgments under the Insolvency and Bankruptcy Code which have been passed by the Supreme Court, the NCLAT, etc. And you will find reference and details in those regards in the note which has been circulated, which Rishikesh referred to earlier. Now, in addition to the financial creditor, another important kind of entity who can maintain an application under the NCLT, before the NCLT under the IBC, is operational creditor, which we discussed earlier. Now, the procedure for filing of an application by an operational creditor varies from the one which a financial creditor could file. As we discussed earlier, there is a huge difference in how operational creditor is treated from a financial creditor for a variety of reasons. So the operational creditor is usually an entity who has supplied goods, or an individual, an entity of whatever kind, who has rendered services to the corporate person. Now, what is necessary is that a notice needs to be issued demanding the sum of money which has, according to the creditor, become due and payable. And if that notice is not dealt with, responded to within a period of 10 days, then the the operational creditor who has issued such notice can file the application. Therefore, it is mandatory for an operational creditor, unlike a financial creditor, to issue a notice under Section 8 before an application under Section 9 is filed. The debtor having a period of 10 days to point out the existence of a pre-existing dispute. Now, I will elaborate a little later on pre-existing dispute, but in short, there must be a dispute which must be pointed out by the corporate debtor to avoid the consequences of an order of admission being passed against the corporate debtor. Now, coming back to pre-existing dispute. A pre-existing dispute would be a dispute which has been raised by the corporate debtor in regard to the debt which is claimed in the Section 8 notice before the Section 8 notice is issued. Now, let us take an example. If goods were supplied, for example, on 1st January 2018, the period of credit was 30 days. A notice is issued in March 2019. Now, if there is correspondence between the parties in regard to the quality, in regard to the quantity, or in regard to the amounts payable, during the period between January 2018 to March 2019, and that discloses a dispute raised by the corporate debtor, then in that case, it is a pre-existing dispute between the parties. Similarly, a corporate debtor who has received defective goods or who has received inferior goods could also have instituted before a court of law seeking damages, or could have invoked arbitration and thereby raised a dispute in regard to its liability to make payment. In both these situations also, there is a pre-existing dispute. So these kind of pre-existing disputes fall within the realm of the expression pre-existing dispute as enunciated by the Supreme Court in the case of Mobilox Innovations versus Kirusa Software. And in this judgment, the Supreme Court made it abundantly clear that there must exist a dispute before steps are taken by an operational creditor under the provisions of the IBC. Once the NCLT finds that there is a pre-existing dispute, post that, the NCLT is not required to, not expected to examine whether that defense will eventually succeed or not. That is the job of an appropriate authority, namely a civil court or whichever other judicial forum before whom parties take their disputes for adjudication. Once it is seen by the NCLT that there is a pre-existing dispute, what it should do is it should relegate parties to their normal rights and remedies under law, and it should therefore, as a result thereof, not take up that application and reject that application so far as the operational creditor's claim is concerned. Now the third category, after the second category, namely operational creditors, is that the corporate applicant is the corporate itself. Now in this case, when it finds that it is facing financial stress and therefore should give a fair chance for undergoing a resolution process, it can make an application. It is like putting an application for yourself to bring about a closure of the company, initially by trying to find a suitor for the company, and thereafter, if there is no suitor for the company, then, well, eventually liquidating the company. Now, therefore, with these three kinds of methods or roads to reach the CIRP process, now let us, the next thing which we must see is what happens when an order of admission in regard to a claim by a financial creditor or an operational creditor or the corporate applicant's own application is taken up. Now, there are three major consequences of an order of admission. The first consequence of admission is that the interim resolution professional, who is an officer, as we discussed earlier, appointed by the NCLT, takes charge, control, and is vested with all rights, all powers in regard to the corporate person. Therefore, the corporate debtor is now the baby, is now the entity controlled absolutely and completely by the resolution professional. The promoters, the board of directors of the company cease to have any rights in regard to any decision-making process in regard to the company. So, therefore, the resolution professional steps in the shoes of the promoters of the company, steps in the shoes of the board of directors of the company, and assumes complete charge in regard to the affairs of the company, in regard to the possession, control, rights in regard to the assets of the company, whether it be immovable property, whether it be movable properties, whether it be claims, whether it be recoveries, whether it be bank accounts, or whether it be movable property. So therefore, this is an important consequence of an order of admission, that the charge in regard to the company, its assets and its rights and obligations move completely from the promoters of the company in the hands of the resolution professional. The next important consequence which we must bear in mind is the moratorium which is available and applicable to the corporate debtor. Now, what is moratorium? The moratorium is that for a period of 6 months, that is while the CIRP process is undertaken to ensure that a suitor is found, somebody who is interested in paying a price and taking over the company and its assets. Till that time, there has to be a freeze of all actions against the company. There has to be a freeze in regard to all assets of the company. There has to be a freeze in regard to all steps that can be initiated by any party who has rights against the company of any kind whatsoever. So therefore, this moratorium is a, so to say, blanket protection available and given to the company while the CIRP process is undertaken by the resolution professional. The third essential consequence is that a public announcement is made by the resolution professional immediately upon an order of admission being passed, inviting claims from all creditors or any party who has any right of any nature whatsoever against the corporate person, so that the resolution professional can gather all details and all data in regard to the creditors of the company as early as possible. So therefore, you all have seen that the consequences of an order of admission are that the promoters are divested in regard to all the rights in respect of the administration and management of the company, and there is a moratorium which is enjoyed by the company during the period that the CIRP process is required to be undertaken by the resolution professional. Now, once a public announcement is made, claims are invited from all parties, which are compiled by the resolution professional, and the resolution professional, from on the basis of the data in regard to the creditors of the company, gives representation to the creditors of the company on what is known as a body called the Committee of Creditors. The Committee of Creditors is very important because all decisions in regard to the running of the company, in regard to issuance of a resolution plan, inviting bids for resolution applicants who are interested in taking over the company, and the eventual decision as to whether a resolution plan put in by a resolution applicant versus another resolution applicant should be accepted, not accepted, rejected, modified. All of them, all these examination, evaluation and decision making is done by the Committee of Creditors. So moving ahead, what essentially the resolution professional does is, once it takes charge of the company, all the employees of the company are answerable to the resolution professional. The resolution professional enters the office of the company and starts operating from there, and starts making lists of assets of the company, liabilities of the company, the raw material available with the company, the goods which are available with the company, the machinery of the company, the immovable assets of the company, and whatever else in regard to the company, whether tangible or intangible, which has value. In short, it starts preparing a balance sheet as of the date of admission, so as to ensure that the resolution professional is, on the basis of that data collected, able to weave in a proper expression of interest for interested parties to bid for the company as and when there is an invitation for bid issued by the resolution professional. Therefore, the resolution professional is in short vested with powers to manage the company, take all steps as the board of directors would have taken, issue instructions to the employees of the company, and based on the data collected, constitute a committee of creditors for the purposes of taking decisions in regard to the resolution plan of the company. Now, after that, what is found is that there is a resolution plan which is to be undertaken within a time limit. And therefore, once all this data is gathered, on the one hand, the resolution professional must protect and preserve the properties of the company, try and manage it as a going concern, for which purpose he can appoint accountants, legal professionals, and raise finance also if necessary, as also modify or enter into contracts. Based on this data which has been gathered, the resolution professional must prepare an information memorandum which is eventually to be made available to the parties who express interest in the resolution plan in regard to the company. Now, once all that is done and necessary advertisements are issued for invitation of expression of interest, prospective resolution applicants who will take interest in acquiring the company as a whole, whose eligibility has to be checked. Eligibility has to be checked because no entity or individual connected with the promoters of the company, nobody who is related with the corporate debtor who is in default, or no entity who has who is within the Indian financial market, a defaulter in regard to any of its obligations, should be eligible to apply and to take over a company. Therefore, all eligible resolution applicants are thereafter to be provided with the information memorandum and the document also known as the evaluation matrix, that is the weightage to be given in regard to the various terms and conditions which are expected of the prospective resolution applicant. It is on the basis of all this that a resolution plan is to be submitted containing data and details in regard to what a resolution applicant proposes to do in regard to the company, its assets, its employees, and most importantly, its creditors, namely, how much money does the interested resolution applicant propose to pay each class of creditors, and it is on that basis that there is an evaluation matrix weightage which is contemplated under the provisions of the IBC. Now, once these resolution plans are put up, then they are evaluated with the help of legal professionals as also professionals associated with evaluation of resolution plans for companies. And what is required thereafter to be done is this resolution plan is required to be put up for vote before the committee of creditors. The committee of creditors would thereafter vote on this resolution plan, and with the necessary percentage, earlier it was 75, now it's reduced to 66, the resolution plan would be voted upon, and upon the resolution plan being voted upon, if it is voted in favor, that is more than the threshold percentage of the financial creditors and the creditors otherwise forming part of the committee of creditors vote in favor of the resolution plan, then it is incumbent on the resolution professionals thereafter to put up that successful resolution plan before the NCLT for its acceptance. Now, this percentage of 66%, once it is achieved, there is practically no judicial interference expected or contemplated by the NCLT insofar as the resolution plan is concerned. Meaning thereby that the final decision maker in regard to which resolution plan has to be accepted is dependent on the commercial wisdom of the committee of creditors, and it is not as if this commercial wisdom is capable of being reviewed in a judicial way by the NCLT. NCLT has no scope of looking into the commercial wisdom expressed by the committee of creditors, and therefore all that the NCLT can look into when this application is made is that does it meet with the rigors of the law as required, and is it following all the steps and all the necessary needs that the IBC provides for, namely participation of all committee of creditor members, issuance of proper advertisements, and consideration of necessary weightages and information being provided to the promoters as is required. Once all these legal steps have been correctly taken as contemplated under the IBC, the NCLT has to proceed on the basis of putting its stamp on the commercial wisdom of the committee of creditors. Another aspect before the resolution plan is taken up is the avoidance of transactions which the resolution professional is required to undertake. Namely, all transactions which have a taint, which result in value loss on the part of the corporate debtor, and which fall within the look back period, that is the period of 1 year in a given situation and 2 years in a given situation. Under the IBC, those kind of transactions are capable of being avoided by the resolution professional when they are found to be as a result of malfeasance or misfeasance, or are not found to be in the usual and ordinary course of the corporate debtor. Now, in all these situations, these transactions, when avoided, are capable of being questioned before the NCLT, but that is therefore the avoidance of transactions aspect, which also needs to be undertaken by the resolution professional before a resolution plan is drawn up before it is put for vote, because that has a bearing on the assets and liabilities of the company. Well, therefore, the next question which arises is, what happens in case there is no resolution plan? In case there is no resolution plan, or if there is a resolution plan but that resolution plan is rejected by the committee of creditors or the NCLT as the case may be, then there is an order of liquidation under section 33. And once there is an order of liquidation, the liquidator steps in the shoes of the resolution professional and prepares necessary reports, assets memorandums, and thereafter proceeds in consultation with the stakeholders to proceed to sell the properties and accumulate all the money which comes in the hands of the liquidator as a result of the sale of the assets. This money which is accumulated is thereafter to be distributed between the stakeholders in the company, and the first right in regard to this money is for costs incurred during the resolution process and thereafter the liquidation process. Thereafter, the money goes to secured creditors and the workmen, and thereafter to certain kinds of workmen who have worked for the last 1 year, and eventually thereafter to unsecured creditors and governmental and statutory dues and so on and so forth. Now, that is therefore broadly the working. And it, at the end of it, if I had to tell you all three important things which we have kind of noticed in this discussion over IBC, the three things which come foremost to my mind, and those things are, well, finally we have a legislative framework, a statute, which tells us within a time-bound period as to what happens in regard to a company which is in default. And that is the time-bound mechanism provided under the IBC is the most striking feature and the reason behind the success of the IBC. The second striking feature and a very important aspect is that the defaulting promoters no longer remain in control of the assets or the management of the company. Well, and the third important aspect is after an effort of 180 days extendable to 330 days, if there is no successful resolution in regard to the company goes in liquidation and thereafter assets are sold within a time period. With these three essential features in the last 3 and odd years, there has been a complete change in the recovery mechanism of money so far as India is concerned. And that's why in one of the articles written by a journalist, NCLT has satirically been described as a graveyard for companies. Well, that speaks volumes about how successful the working of the IBC has been, because we must all accept at the end of the day that while a company has its reasons for not paying money, imagine the plight of a creditor who doesn't get the money which he is entitled to get. So with that little conclusion, I think that our discussion for today ends with one note that in the last 4 years or thereabouts that the IBC has been operational, more than 3,600 companies have been admitted, and while only 200 have been resolved and 800 have gone for liquidation, there are large number of companies which have also entered into settlements. And my experience in practice says that this is among the most effective legislations that I have seen in my career as a lawyer. And it was high time that creditors were dealt with better and not made to feel helpless insofar as their recovery of claims against errant corporate debtors is concerned. Today's newspapers announced the failure of Mr. Vijay Mallya in his extradition proceedings. And so we have people like Mr. Mallya, Mr. Modi, who have disappeared from the face of this country in order to avoid claims by their creditors, which is not a great thing to happen for our economic environment and for the business community as a whole. Thank you very much.
Now I would request participants, if they have any questions, they may just punch in the question and answer section down below the screen.
Mr.
One
Vyas,
of
I think everybody's had enough for the day, and we'll reserve question
Sure,
answers
sure.
for some other day.
So now I'll request Mr. Menon to offer his views.
Thank you, Mr. Vyas. I have always found that a layman finds the Insolvency and Bankruptcy Code to be a complex legislation with the code and a multitude of regulations that follow it. But I think in the last a little more than an hour, Mr. Kapadia has summarized that entire code, the entire gamut of provisions that are now available under the Insolvency Code, and provided a very simple and easy to understand uh, mechanism, a very easy to understand seminar on the Insolvency and Bankruptcy Code. I think this has been extremely informative for all of us, and it's been an absolute privilege to have you with us, sir.
It's fun at my end also. So I wish both of you all and all our participants very safe time at home and good health for them and their family members. And on that note, goodbye and take care.
Thank you
Thank
very
you.
much, Chetan bhai.
Thank you.